Review Board to order. Good afternoon, everyone. We have very light attendance today, as was to be expected. However, we do have a quorum, so we can get started. Hopefully, everyone's had an opportunity to take a look at the minutes. Does anyone have any additions? Any mistakes you caught? If not, I would entertain a motion to accept.
I move.
Thank you. May I have a second, please? All in favor of accepting the minutes, please raise your hands. Minutes approved. Thank you. And turning it over to the Inspector General.
Good afternoon. I was going to just do a brief update. I think everyone has in front of them the third quarterly report. And so I'm just going to go through a few things just to highlight. I know it's a busy day. And if there's any additional questions, please let me know. If you go to page 5, down at the bottom where it talks about citizen complaint stats, just in summary, in the third quarter, the DIG received 451 complaints from citizens. Again, the majority of the complaints we receive are via the hotline. We also, during the third quarter, we closed 393 complaints. Were closed mainly due to insufficient information. And again, we do try to follow up with the complainants to get additional information if their phone numbers or contact information is available. Out of that, 30% was referred to another agency, and at least 17% of what we looked at based on the allegations did not involve any type of police misconduct. And we do make it a point to, when we're doing that, to follow back up with the complainant to kind of let them know that it didn't involve police misconduct. Out of the complaints we have, the top allegations were actions taken, not taken, rude and discourteous, and force. That's just giving you an overview, the statistics and everything. If you were to go through the next couple of pages, you'll see more of a breakdown. But I did want to draw your attention, if we could, to page 9. So 9, when we talk about investigation disposition per allegation, just wanted to give you just an overview. For the third quarter, you can see what exonerated, sustained, unfounded, what those totals are. For exonerated, we had 22. Sustained were 22. Out of the complaints we investigated, investigations that were open, 98% were unfounded. We had 19 that we closed administratively, and 3 were withdrawal. And then if you look at the next total, the next column below that, next column beside that, you'll be able to see what the totals were for quarter 1, 2, and 3. And then if you can turn over to page 10. If I'm going too fast, please let me know. These are just some things I just wanted to point out because these are questions that we normally get from the board members, and I just wanted to just point these out. If you look at page 10, if you look up under H, it talks about investigative allegations and dispositions of findings. This is a accumulation of all 3 quarters. You'll see there was a total of 344 allegations that were reviewed. And if you see the breakdown by the Civilian Review Board, you'll see that the board agreed with 341% of those, not percent, 341, and they disagreed with, and the board disagreed with 3. You'll see a little footnote there. That footnote allows you to go to the bottom, and it points out the cases in which there was a disagreement. In case the board wants to look at those cases, they can just let us know. We can definitely get those cases to you. And if you go over and you look at the chain, so keep in mind that once the cases are reviewed by the board, they do go over to CPD for review. So we only, this is just based on what we have gotten back from CPD. So what we can tell you is we've received that CPD for the ones they reviewed, which was 205. They have agreed with at least 197 of the findings, and they've disagreed with at least 8. And again, the little footnote tells you which cases that CPD did disagree. And the percentage I felt is really good, stating that, the board finds 99.1% that they confer with the findings from the IG's office. And again, CPD reviewing the same allegations, they have conferred with at least 90% of the findings with the office. And just wanted to piggyback to say we have started establishing our quarterly meetings with CPD. And so part of the things that we're discussing will be some of the complaints in which there was some disagreement with. We like to kind of learn why they disagree. We're just looking at those and following up. What I can say is some of the complaints that we were discussing, it's a learning process. We all know, just like, they're learning our processes, we're learning theirs. So some of the disagreements may have come from cases 2022, 2023. We're not really finding that they're disagreeing too much with a lot of the cases that we're submitting in 2024. And that's pretty much what the leadership said when we were talking about some of the cases, that as time is going on that we're learning. So I love the fact that I had that communication with CPD, and again, it's just a matter of learning and doing that collaboration with the department. Just going back further, if you look at it talks about DIG investigation reports reviewed. So for the first 3 quarters, the Civilian Review Board has reviewed 183 cases, complaints. And out of that, at least for this 3rd quarter, we know that we have received at least 90 cases back from the chain. Again, keep in mind that that doesn't necessarily mean they're the same, because we get the cases back based on when we submit them. So some of those are going to be 2023 cases. If you go into the second number J, which talks about chain of command, corrective actions per allegations, what we can say is within the first 3 quarters, at least 187 allegations were, no further action was taken. 7, there was corrective counseling that was done, and then we had 9 that had positive corrective action, and then 2 were written reprimands. And what we did is if you look below there's some definitions, because we know that there were some questions that was followed up, specifically what does that mean. So we did provide definitions for that. The definitions come directly out of the collective bargaining agreement. If there's any additional information that the board wants, we can definitely provide that, because depending on the type of corrective action that was taken, the collective bargaining agreement also states how long it stays in the officer's records. So that's why they're kind of listed differently. Are there any questions?
Do we know the nature of the 187 reports of no further action from chain of command? Do all those fit in like the same category, or because if just for the sake, I imagine this question is going to come up, if chain of command agrees with 96% of the recommendations but took no further action on 187, what does that mean, or where did those fall, or what types of allegations or things were those?
So what we're looking at, so the 187 no further actions, those would be the investigations that we submitted that we found that we did not recommend any type of action be taken. So either the unfounded, exonerated, right. So that was just telling us that they didn't do anything, any actions out of the ones that we did provide some type of sustained action. Then it tells us what was taken. And again, one of the things that I can say, again, when it talks about disagreement, so we know that there's 8 out of the 205 that we received, 8 they disagreed with. And so we did footnote those, and those are in the report, because those would tell us specifically they disagreed, and it could be why. Some of the ones that I can tell you we looked at, could have been, again, some of them, if they were in 2022 or early on 2023, based on timelines, could be different reasons why they disagreed with the findings, and so they didn't take any action. But we do have those report listed, and we can provide those to the board if the board would like to see exactly why, because it's explained on the route slip.
Okay, thank you. Any other questions? Yep.
Yeah, I just have a quick question. So I noticed that from 2023, we received more complaints in total than we did in 2024, it looks like, just in general overall, from the sheer number. And I was looking at the investigation breakdown by allegation type, which I like this because it shows quarter by quarter what the allegations were in the categories. What I was curious to see if you all had, or could include in the Q4 report, is the 2023 breakdown of the allegations or the categories of allegations. So that way, when we're looking at this, we can do some comparisons to see where those trends are and to identify the decrease, if it's similar or different. I'd just be curious to know that. So if you could do that for the Q4 report, that would be great.
I know what you're saying, and let me look at, because I know, like, even though it's got like quarter 1, 2, and 3, we do know that some of those reports are not 2024 reports. Some of those are 2022, and some of those are 2023.
Okay.
So, yeah, because we do know at the beginning of when the board started reviewing the reports, even though we were doing reports in 2022, the board didn't start reviewing them until 2023. So if you're asking if we, and it sounds like this might be what you're asking, if we can go through and break the reports down by year versus quarter, because we just break them down based on when we get the reports back, because it takes time. There's some reports that we might put on administrative hold for a certain length of time, and then it may be open, and so it may come in this quarter, but it's not necessarily a 2024 report.
Oh, okay. Yeah, I was just seeing if just this chart that you have, this investigation breakdown by allegation, and you see how you have 2024 for Q1 to Q2, Q3, and Q3, and then the totals. If you could just do the same thing for 2023, if you have that.
For the 2023?
Yeah.
Okay.
Yeah.
Yep. Okay.
Thank you.
Okay. Were there any other questions? Oh, sorry.
I just have one quick question here. Where it says documented constructive counseling, where does that counseling come from? Could it be from the sergeant, or is it maybe a class, or is it a combination of? Do you have any idea what that means?
I can find out specifically. We have it down here just as a definition. So we know it, based on the contract, what it tells you, the constructive criticism, the documented constructive counseling would include. It just says it's an initial step of formal corrective action, but not an action of record. That might be more of a written reprimand, and a written record of the basic facts of an incident which was brought to the attention of the sworn member, together with a summary of remedial action required. So from what I can see, just from what we're able to see when it comes back, that's documented, it's either coming from the supervisor, which could be the sergeant, or the lieutenant that's documenting that this is what they did.
Okay, and then out of the three, the documented, the positive corrective action, and the written reprimand, would those three actions stay in an officer's file for different lengths of time, or the same lengths of time, or do we have any idea?
So it is in the contract. I can actually pull it up, and actually, because you're going to be speaking on the contract, right?
Yes.
Okay, so, yeah, so we do know that they stay in the folder for different times, different length of time. Off the top of my head, I just don't know that. But I know that we do have a new contract, and it might be in there that does state the definitions. I couldn't remember what part of it. You have it, is it 10?
I think
It was
it's in Article 10.
Yeah.
So the positive corrective action is, maybe that could be, maybe that's the more formal counseling if the officer, if maybe it should be a little bit further than just speaking with your sergeant, and then the positive corrective action is the counseling, if that's needed? Is that maybe what this means?
No, those are the levels of progressive discipline. I
Okay.
think they'll talk about it in the FOP contract.
You'll talk about that?
If you have any specific questions, I'd be more than happy to answer
Okay.
related to that.
That'd be good. All right, thank you.
Were there any other questions? Okay.
Thank you. All right, next up, we will have our review of FOP contract updates. We are joined this afternoon by a representative from the City Attorney's Office. Would you mind introducing yourself? And I believe what the board is looking for is any FOP updates that specifically impact the board in our review of cases. And then I'm imagining folks will have questions for you as well.
Thank you.
Yes.
Good afternoon, everybody. My name is Paul Bernhardt. I am the Deputy Section Chief of the Labor and Employment Section with the City Attorney's Office. We do the labor arbitrations that come about from discipline. We have a familiarity with the FOP contract, so I'm happy to answer any questions you have about the new FOP contract. And it's really not so new. It's been in effect since December of last year. But I understand that there was the first question was whether there was any changes to the contract that affected you all and the procedures that you follow. And I'm sorry to disappoint you, but there is none. Article 8 generally governs investigations and what the Department of Inspector General's office does, as well as what the Civilian Police Review Board does. And there's nothing in Section 8 of any substance that affects what you do, except for, and I don't know, Madam Inspector General, there was a provision eliminated. The contract used to allow for polygraph examinations during investigations under a limited set of circumstances. One of those circumstances would be if an officer under investigation wanted to clear himself and requested a polygraph. If the chief of police allowed it, a member under investigation could submit to a polygraph exam. That has now been taken out of the contract altogether, so there are no circumstances that would allow for polygraph examinations to be used during investigations. But beyond that, nothing has changed in Article 8. I understand from Tiara that there's been some questions about timelines, so I did want to review that just briefly and answer any questions you had. In Section 8.14 of the contract, it requires that investigations of citizen complaints be completed within 90 days from when the Department of Inspector General receives the complaint. The contract has favorable language for the city that allows for extensions of that 90 days with the FOP if the FOP agrees to it, and the contract says that the FOP, unless there's no good reason not to agree to it, that they should. So I don't know if that's an issue that you've been facing, or if they have been agreeing to extensions on your cases, but the contract certainly allows for an extension to those 90 days. If an investigation is not completed within 90 days, the article speaks to that. And the article also throws in a different number of 180 days. And the contract says that an arbitrator shall consider the result of the applicable time limit not being met, or if the investigation otherwise exceeds 180 days as part of his or her analysis related to any discipline arising out of the investigation. And it's my understanding that there's been some questions about if an investigation is not completed within the time frame, what can we do with it? And my response to that would be, you can still consider the investigation, you can still recommend whatever form of discipline to the division. It only becomes an issue if the case goes to arbitration, that an arbitrator can look at whether if the investigation took beyond those 90 days or beyond the 180 days. That can be factored into an arbitrator's decision, in whether to sustain the discipline. We haven't seen any of those cases yet. I've not arbitrated, that issue before, but I feel comfortable that if we had a good basis for the delay in the investigation, if we needed to, if we needed additional time to conduct the investigation, even if the union doesn't agree to it, I'd rather have a complete and thorough investigation to take to arbitration rather than one that was hurried because we were trying to meet contractual deadlines. So keep that in mind. But there's certainly, these timelines do not prevent the board from taking action on any cases, whether the timelines are met or not. Now, of course, in an ideal world, we would always meet the 90-day deadline, but of course, there's circumstances in which that's not the case. But my recommendation to you all would be, don't let that be a reason for not pushing a case through that you feel discipline is warranted on. We can address it on the back end at arbitration. So does anyone have any questions about timelines or anything else related to investigations specifically? And if not, I'd welcome any other questions you have on the contract. And I believe there was one related to records retention of discipline in an employee's file. Yes?
Could you address that? Maybe just a little clarification of what it means and how it affects the officers.
Yes.
Okay.
The contract requires that the division use progressive discipline when disciplining officers, except in certain circumstances, which we'll discuss in a moment. But progressive discipline generally stands for the proposition that we have to give the lowest level of discipline first, and then we can increase that. And I can direct you to Article 10 of the contract has the levels of discipline, the documented constructive counseling, to a written reprimand, to a suspension. So each of those, the division's required to, on a first level of discipline or first, case of discipline, issue the documented corrective counseling. If there's discipline, again, within a certain time period, the division is required to give a written reprimand, and then a suspension, and then all the way up into termination. Now, in instances of critical misconduct where there's been allegations sustained of critical misconduct, progressive discipline can be set aside, and the division has the discretion to implement or to give whatever level of discipline it deems fit. So, for an example, I know that a couple years ago there was a change in the directives where EEO violations are now defined as critical misconduct, that if there's a sustained finding of an EEO violation, progressive discipline can be bypassed and discipline can be handed down all the way up until termination. Again, and we see those in use of force cases a lot where there's, maybe not verbal insult, but where there's been significant use of force and it's been a sustained finding of excessive force. That oftentimes is considered critical misconduct that progressive discipline can be bypassed. Does that answer your question?
It does.
Okay, thank you. And then did you still have a question about the timelines?
No, because where I had the question, underneath it had the progressive discipline, and then you've answered how it, so thank you.
Any other questions?
Does
you,
not
Madam
look
Chair.
like it. Thank you very much. We appreciate you coming and being willing to answer questions from the board. All right, next up we will go to case reviews. I'm going to actually start with review team 1, then we'll go to 3. We are missing Mr. Strickland, but we do have at least an update on one of team 2's cases, so we'll come to that after teams 1 and 3 go. So turning it over to Dr. Jones.
All right. So we didn't have too many cases, just 6, so this should be fairly quick. On May 28, 2024, City of Columbus Department of Inspector General, they received a complaint alleging misconduct by a Columbus police officer. The complaint explained that her daughter was taken by officers to a behavioral health facility, and the complainant alleged that during the daughter's arrest, the officers broke her cell phone. The DIG investigation consisted of a review of the CAD data, the event chronology report, CPD unit history, also body-worn camera footage for the focus officers. They also interviewed the complainant. And the investigation found no evidence to substantiate the complainant's allegation. Additionally, the investigation found no evidence of damage to the cell phone during the officer's handoff to the Children's Hospital staff. So that it is recommended that the allegation against the officers be closed as unfounded. We reviewed that and we agreed with the findings of that. And that was case number 2024-0810. Moving on to the next case, 2024-0957. June 24th, 2024, the Department of Inspector General received a complaint alleging police misconduct by a Columbus police officer. The complainant stated that she was a sexual assault victim. She alleged that the officer assigned to her case did the following: went on vacation and failed to provide a case update information to her. The officer made a rude and victim-blaming comment, and the complainant alleged her case was not being handled appropriately. The DIG's investigation consisted of a review of the CAD data, an interview with the complainant, an interview with the focus officer, a review of the officer report summary, as well as CPD policies and procedures. As it relates to allegation 1, the officer did not provide a case update prior to going on leave. The investigation showed consistent documented contacts with the complainant prior to the officer going on leave, so that therefore it is recommended that allegation be closed as unfounded. The second allegation, the investigation found no evidence that the officer made a rude and victim-blaming comment to the complainant, so no evidence was found to substantiate that allegation. So that one is also recommended to be closed with a finding of unfounded. And then allegation 3, where CPD investigation was alleged to have not been handled properly. There was no evidence to substantiate that investigation as well, or that allegation as well. And so it is recommended that allegation 3 be closed with a finding of unfounded. We reviewed all of that and agreed with the outcomes of that. The next case was 2024-0983. On July 1st, 2024, complainant filed a complaint with the Inspector General's office alleging police misconduct and excessive force. The complainant alleged on June 28th, 2024, while visiting a local carryout store, an officer approached him with their weapons drawn, and the officer slammed him on the ground, pointed a gun at the back of his head, and the officer put his knee on his back when he was placed in handcuffs. The DIG investigation consisted of a review of the CAD data, an interview with the complainant as well as the focus officer, a review of the body-worn camera footage, a review of information from the Emergency Communications Center, and a review of the policies and procedures for the Columbus Division of Police. In regards to allegation 1, the investigation found no evidence to substantiate the complainant's allegation that the officer slammed the complainant on the ground. The body-worn camera footage actually shows the officer ordering the complainant to the ground, and the complainant complied with no resistance. So that recommendation is that the allegation be closed as unfounded. For allegation 2, body-worn camera footage showed that showed after the complainant complied with the officer's instructions to get on the ground, the officer approached the complainant, put him in handcuffs, and so the investigation found no evidence that substantiated the complainant's allegation that the officer pointed a gun in the back of his head. So that allegation, the recommendation is for that allegation to be closed as unfounded. And then allegation 3, the investigation found the complainant was instructed to get on the ground, then placed in handcuffs, but there was no evidence to substantiate the complainant's allegation that the officer put their knee on the complainant's back. So that one is also recommended to be closed as unfounded. We reviewed this case and also agreed with the findings as well. Case number 2024-0990, the complainant filed a complaint with the Department of Inspector General. Complainant alleged she did not receive notification from officers that her juvenile son was detained and questioned by them. The complainant also alleged officers ignored her son when he tried to alert them that his handcuffs were placed on too tight. So, DIG's investigation consisted of a review of CAD data, the body-worn camera, the cruiser video, and then a review of applicable policies and procedures, a telephone interview with the complainant, and in-person interviews with the officers that were involved. In regard to the first allegation that the officers detained and questioned the complainant's son, the investigation found the officers' actions to be within CPD policy, so that one is recommended to be closed with the finding of exonerated. The second allegation is that officers ignored the complainant's son when he tried to alert him about the handcuffs being too tight. The investigation did not find evidence to substantiate that complaint, and so it is recommended that that allegation be closed as unfounded. We reviewed this case and also agreed with the outcomes. And then I think this is the last one, case number 2024-1067. On July 18, 2024, the complainant filed a complaint with the Department of Inspector General alleging misconduct by a Columbus police officer. This complaint stemmed from a custody dispute. The complainant alleged that an officer confirmed an emergency custody order was in place. However, the court records indicated that there was actually never a court order in place, just a motion. So the Columbus DIG investigation consisted of an interview with the complainant, interview with the involved parties, interview with the focused officer. They reviewed the body-worn camera footage as well as custody paperwork, CPD policies and procedures as well. The investigation found the officer did tell the complainant that there was an emergency custody order in place, and when there actually was not. There was only a motion put forth in regards to the emergency custody. Therefore, DIG recommended that that allegation be closed with a finding of sustained. The officer identified the custody paperwork as a court order when it was just a motion. We reviewed this and we agreed with this finding. We also had a question about this case in particular in terms of what type of training officers receive as it pertains to interpreting legal documents, and I don't think I saw the response to that just yet. So were you able to find out?
Follow up on that. I know that I had sent it over to my supervisor, and I think they were trying to reach out to the academy to get some follow-up information on that.
Okay.
And I apologize. We'll probably text now just to see if we got some follow-up, but we didn't get anything back to you yet.
Okay. So that was what we had for that, but we did agree with the finding as well, and that is all of our cases. So I move to accept the findings, or are you going to do that?
Yeah, you can move. I'll make sure you hit all of them.
All right, so I move to accept the findings of case number 0810, case number 0957, case number 0983, case number 0990, as well as case number 1067.
Okay. It's been moved. May I have a second, please? Okay. Does anyone have any questions on any of those cases? Okay, seeing none, all in favor of accepting those cases as recommended, please raise your hands. No abstentions, no oppositions. Thank you. Turning it over to Board Member Younger for
Case
your
number
case numbers.
2024-0870. This is a complaint against a CPD officer. The complainant alleged that the vehicle was wrongly suspected of being a stolen vehicle and impounded by the officer. The DIG's investigation consisted of CAD information, EEC review about BWC footage, and CPD impound documentation. A review also of CPD policies. Regarding the allegation that the officer wrongly impounded the complainant's vehicle for suspecting it to be a stolen vehicle, the investigation found the officer's actions were within CPD policy. It is the recommendation of the IG that the allegation of this officer be closed with a finding of exonerated. The Columbus DIGs, however, had another allegation that was added, and this is because the officer failed to complete a required report pursuant to the policies. It is recommended that an additional allegation be closed with a finding of sustained because it was a violation of CPD policy and procedure. And this was Directive 6.01, which allows for tow, and it was a report that the officer failed to complete. We reviewed it, and we agreed with the finding of the Inspector General as to this particular case. Number 2. Case number 2024-0988. This was the complainant alleged that, number 1, she was stopped by officers due to her race, and number 2, the officers lied to her stating that her tags did not come back registered. The DIG's investigation consisted of interview of officers, review of BWC, review of policy and procedure. The investigation revealed that the officers initiated a traffic stop with the complainant due to the tags of the vehicle, due to the tags of the vehicle the complainant was in, not showing registered to OLAG system. After gathering the vehicle owner's information, the officers were able to find the vehicle in the OLAG system. The officers thanked the complainant, apologized for explaining that there was a system error. The officers at no point lied to the complainant. As the officers' actions did not violate CPD policy, the Inspector General closed it as unfounded. Our committee reviewed it, and we agreed with the finding of the Inspector General. Case number 2024-0993. The complainant alleged in this case that the officer made rude and disrespectful comments about the victim by stating that teenagers need to be beat. She got what she deserved, and kids her age steal cars and run the streets. The complainant also made a second allegation. The officer indicated that the victim likely deserved the force that was used against her by a family member. The DIG's investigation consisted of an interview of the complainant, CAD data, review of BWC footage, interview of officer, and CPD directives. As it pertains to allegation 1, the investigation found no evidence to substantiate the allegation that the officer made rude or disrespectful comments about the victim by stating that teenagers need to be beat, she got what she deserved, and kids her age steal and run the streets. Therefore, the DIG recommends that this allegation be closed as unfounded. As it pertains to allegation number 2, the investigation found evidence to substantiate the allegation that the officer stated that the victim likely deserved the force that was used on her by a family member. The officer did state, quote, "I guess she deserves to be dragged and laid on if she is going to be hitting a guardian or a parent," end quote, which is a violation of CPD policy. The DIG recommends that this allegation be closed as sustained. Our review committee discussed this in length, and we do agree with the finding of the Inspector General as to this case. Okay, thank you. Case number 2024-1018. The complainant in this case, the complaint stemmed from the officers responding to an incident that was dispatched as a person with a gun. The complainant alleged, 1, the officers responded to his residence with guns drawn. 2, the officer entered his residence without a warrant. 3, he was improperly detained during his encounter with the officers. And 4, the handcuffs were placed on him so tightly that his wrists were bleeding and bruised. The DIG's investigation consisted of an interview with the complainant, a review of the police report, a review of BWC footage, CPD directives. The investigation found that the alleged incident occurred for allegation 1 and 2. However, all the responding actions officers were within policy. The DIG recommends that allegations 1 and 2 against the officers be closed as exonerated. Additionally, the DIG recommends that 3 be closed as unfounded, as the detainment was not improper due to the nature of the dispatched run, and officers' actions were within policy. Lastly, the DIG recommends allegations 4 be closed as unfounded, as the handcuffs were not too tight and the officer's actions were within CPD policy. Our committee reviewed it, and we also agree with the finding of the Inspector General. As to number 5, this is case number 2024-1061. This was an allegation which stemmed from the arrest of the complainant's husband. The complainant alleged, 1, the officer towed her vehicle for no reason, and 2, she was improperly detained, and she alleged that her rights were violated due to vehicle being searched. The DIG's investigation consisted of review of BWC footage, a review of Ohio Department of Rehabilitation and Correction records, Franklin County Municipal Court records, paperwork from Columbus City Code, review of CPD directives. The investigation revealed the officer did tow the complainant's vehicle, and the complainant was detained. However, the officers did not search the vehicle, but they did conduct an inventory of the vehicle prior to being impounded. The DIG found the officer's actions were within policy for this during this incident. Therefore, the recommendation is that all 3 allegations be closed as unfounded. As the officer towed the vehicle, there was a valid reason, and they were within CPD policy. The detainment of the complainant was not improper, as the officer's detainment was due to the investigation. Additionally, the officers did not search the complainant's vehicle, but conducted an inventory, which is necessary because of the impounding, the fact that the vehicle was impounded. We did review this, and we find that this is within CPD policy and procedure. So, as to all 5 cases, we move to accept the findings of the Department of the Inspector General as to case number 2024-0988, 2024-0993, 2024-1018, 2024-1061. As to case number 2024-0870, we move to accept the finding of the Inspector General as to allegation number 1 and the allegation number 2, which was the allegation brought on by the Department of the Inspector General. We also move that that allegation be accepted.
Any questions on any of those cases from Team 3? Okay, seeing none, all in favor of accepting each of those recommendations and motions, please raise your hands. All right, motion's carried. Thank you. I will turn now to Team 2. There are a number of cases. One I'm going to give an update on and see if there's any call for a vote following that, and then I will review the summaries of the other 6 cases from Team 2 that were holdovers from October, and we'll take a vote on those as well. Let me take just a second to pull each of them up. Starting first with case number 0773. That was a case from September. Just to rehash, the summary for this case was already given. This was an incident when an off-duty CPD officer, a complaint was filed alleging that the officer engaged in unbecoming conduct because the officer was upset about his daughter not making a cheerleading team. And then while engaging in an argument with the cheerleading coaches, hit a water bottle cup across a room. Does everyone remember that case when it was recounted? Okay. We asked that the IG reopen the investigation to look further into whether the officer's conduct was a violation of specifically Rule 1.36, unbecoming conduct. And so after further investigation, the IG has come back and has actually amended their original report to issue a finding of sustained. Okay? So essentially, nothing in the conduct changed, nothing in the report itself changed, except for looking at the conduct through the lens of 1.36. With that now being the IG's recommendation, a finding of sustained, would anyone like to move to accept that recommendation?
I move we accept the recommendation.
Okay, do I have a second, please? All right, all in favor, please raise your hands. All right, motion carries. So for Stephanie, for sake of your notes, that's case number 2024-0773. Okay. All right, next up from team number 2. Okay, that's the one we got. Apologies, I'm opening them each individually. Yes. Okay. Next up is case number 2024-0372. Okay. The summary is this. In March of 2024, the complainant filed a complaint with the City of Columbus alleging misconduct by an officer. The complainant was present inside of a residence where officers responded to investigate domestic violence. The complainant alleged that he was inappropriately questioned about involvement in the incident and wrongly charged for a criminal violation unrelated to the matter officers were investigating. The IG's investigation consisted of a review of BWC camera data, a review of the CAD information, telephone interview with the complainant, and an in-person interview with the officer involved. Additionally, criminal case information from the city prosecutor's office in Franklin County Community Court was reviewed. In regard to the initial allegation that the officer inappropriately questioned the complainant about domestic violence, the investigation confirmed the officer's actions did not violate CPD policy. It's recommended, therefore, that the first allegation be closed with a finding of exonerated. Regarding the second allegation that the officer wrongly charged the complainant for a criminal violation, the investigation found evidence that substantiated the complainant's allegation and the matter violated CPD policies, procedures, and/or law. It's therefore recommended that the second allegation be closed with a finding of sustained. Does anyone have any questions about the findings themselves that you'd like to ask the IG's office? If not, the recommendation is that the initial allegation be closed as unfounded and the second one be closed with a finding of sustained, and that this be forwarded to the police chief in accordance with CPD policies and procedures. If there are no questions, could I have a motion to accept the recommendations given in case number 2024-0372? So moved. All right. May I have a second?
Second.
Thank you. All right. We'll hold that for a vote with all the rest. All right. Next case number is 2024-0784. Summary of this case is that in May of 2024, the IG received a complaint alleging misconduct by a CPD officer, alleging that the detective assigned their case was rude and unprofessional by stating, "I have 100 or more cases open and it is not my priority to update you," when the complainant called requesting an update on the investigation. The DIG's investigation consisted of a review of CAD data, a review of CPD unit history, a review of the complainant communications with CPD, and a review of CPD's email communications with the complainant, an interview with the focus officer, and an interview with the complainant, and a review of applicable CPD policies and procedures. Pertaining to the allegation, based on the information evidence obtained, the investigation found the officer did provide reasonable communication with the complainant. Additionally, the investigation found no evidence to substantiate the allegation that the officer was rude or unprofessional, as reported by the complainant. It's therefore recommended the allegation be closed as unfounded. Anyone have any questions? Okay, without any, I would entertain a motion to accept. Okay, may I have a second, please? All right, I'll save that for a vote on all. This will be out of order, so my apologies. Next up, I've got case number 2024-0886. This is a complaint from June of 2024. The complainant filed a complaint with the DIG alleging misconduct by a CPD officer stemming from the officer's operation of a CPD cruiser. The complainant alleged the cruiser was traveling at excessive speed on the freeway. Here, the IG's investigation consisted of an interview with the complainant, an interview with the focus officer, a review of CPD's cruiser GPS system, and a review of applicable CPD division directives. The investigation revealed the officer did travel at a rate of speed higher than the posted speed limit, and at one point exceeded the posted speed limit by 28 miles per hour. It does not look like there was any exception that he was in pursuit or the officer was in pursuit at the time. Therefore, the DIG recommends the allegation against the officer be closed as sustained. Any questions about that investigation? Seeing none, I would entertain a motion to accept.
So moved.
May I have a second?
Second.
Okay. Next up, I've got case number 2024-0839. This was a case also from June of 2024, a complaint filed with the IG's office alleging misconduct by a CPD officer stemming from the death of the complainant's brother. Here, the complainant alleged that the Division of Police released information to the media on her brother's death before notifying the family. Here, the Columbus DIG's investigation consisted of a review of CPD's media release relating to the death of the complainant's brother and contact with a sergeant within the homicide unit of CPD. The IG attempted to contact the complainant numerous times. However, the complainant failed to cooperate with the IG's investigation. The DIG found that the involved CPD personnel correctly followed policy and procedure while notifying the next of kin as it relates to homicides. In addition, the IG found that the complainant was not the next of kin. Therefore, the DIG recommends the allegation against CPD be closed as an administrative closure.
So moved.
Okay, I've got a motion. May I have a second, please?
Second.
Okay. Next, I've got case number 2024-0914. This is also stemming from June of 2024. In this, the DIG received a complaint alleging misconduct by CPD officer via the hotline. The allegation was that his daughter was hit by her aunt, and officers that responded were not professional or helpful to his daughter. Here, the Columbus DIG investigation consisted of an interview with the complainant, a review of the CAD data, a review of BWC data, interviews with the focus officers, and a review of CPD policies and procedures. The investigation revealed that the officers did not investigate the claims made from the young lady about being hit by her aunt, but instead questioned her about parent custody. After going back and forth with the officers, the young lady ended the interaction with the officers as they did not address the statement she made concerning the situation of being hit and kicked out of the home. The officers kept coming back to the parent custody question, although the young lady made it clear that her mother was not able to care for her. As the officers' actions were in violation of CPD policy and procedure, it is recommended that the case be closed as sustained. And specifically, the directive that officers had violated was Rules of Conduct 1.15, General Requirements, and 1.08, Requirement to Take Action. Does anyone have any questions about that case number? If not, I'd entertain a motion. So moved. May I have a second? Second. All right, last one. Let me make sure I find the right number.
0802. Oh, yeah, I do have it.
Do you have it up?
Yeah. I think we did this stuff.
Is that a repeat?
It's this case. She went inside the gas station and her officer harassed her wife who was sitting in the vehicle.
I'm going to ask, Stephanie, could you look and see whether 2024-0802 may have already been moved and voted on? The facts just sounded a little familiar, so before we... Yep, no problem. While Stephanie looks for that, I will go ahead and move forward on case number 24-0372, case number 24-0784, case number 24-0839, case, yes, no problem.
When you were doing case 0773.
Yes.
We just quoted the wrong corrective code for which we had recommended for the officer. It wouldn't have been 1.36, which would be conduct unbecoming.
Okay.
We changed it and did 1.15 code of conduct, which talks about A1, which would be civil, orderly, and
Okay.
courteous in their conduct and demeanor. So we just wanted to make sure that was correct.
Thank you. I will fix that. I'll amend, if I can, the motion, or at least the conduct rule in the discussion to be 1.15. And I see that on page 5 now. I think I had pulled up the prior version of 0773 when I read that out. So thank you for that. Okay, so moving then the case numbers, I'll just restate them for the record: 24-0372, 24-0784, 24-0839, 24-0886, and 24-0914. We have open motions accepting the recommendations as given and seconds. All in favor of accepting those and moving those forward to the chain of command, please raise your hands. Okay, thank you. Motions carry. And now what we'll do is we'll go ahead and,
I'm just not sure if we did it. It was in
Okay.
my folder for committee 1, so
gotcha. All right, we will, so it looks like this case may have made it into multiple teams review. Just for the sake of, yep, no, you're fine, Stephanie. I just didn't want us to miss it if we did or did not. So I'll go ahead and read out the summary. If it turns out to be duplicative, then we can try to fix that retroactively, not have two of the same complaint given. All right, case number 2024-0802. This is from May of 2024. The DIG received a complaint about police misconduct, specifically an allegation that the complainant encountered an officer while driving a vehicle with bright headlights activated. The complainant said that she yelled profanities at the officer, and the officer then followed her to a nearby gas station. Complainant alleged that a second allegation that she went inside the gas station and that while inside, the officer harassed her wife, who was sitting in the vehicle, by asking her why they switched seats and why she didn't get out of the vehicle and walk around to the other side, and told her that her foot was not broken. The complainant did not recall any other specific language used by the officer during that interaction. The IG's investigation consisted of a telephone interview with the complainant, an interview with the officer, a follow-up call with the FOP representative for the officer, a review of video footage retrieved from the service station, a review of the unit history summary report, and a review of applicable Columbus Division of Police policies and procedures. Pertaining to allegation 1, the investigation found no evidence that substantiated the complainant's allegation that the officer driving the vehicle with the bright headlights activated. Therefore, it's recommended that the allegation be closed as unfounded. Pertaining to the second allegation, the investigation found no evidence that substantiated the complainant's allegation that the officer harassed the complainant's wife. Therefore, it is recommended that that allegation also be closed as unfounded. Additionally, however, the IG found that the officer did not activate his body-worn camera during the self-initiated interaction with the complainant. Therefore, the officer's failure is a violation of CPD policies and procedure. The IG then added an allegation, a third allegation here, to be closed with a finding of sustained. Anyone have any questions about this case or the second allegation or the additional allegation from the IG? Okay. With none, I would entertain first a motion to accept the original report with those initial allegations being closed as unfounded.
so moved.
Okay, may I have a second? Okay, and then I'd like a second motion, if I could, pertaining to the IG's additional allegation in case number 2024-0802, which is recommended to be closed with a finding of sustained. Okay, may I have a second, please? Okay, all in favor of accepting both of those motions as given, please raise your hands. Okay, motion's carried. Thank you. All right, we will now take a 10-minute break. We'll reconvene at 3:10. Yes, I will. are back in session. I'd like to take a moment to introduce Mr. Chris Sewell, who is our, can you give your actual title so that I don't mess it up?
Yes, ma'am. Thank you for being here. My name is Chris Sewell. I am the Assistant Director of External Affairs for Mayor Ginther, and then I also lead Director of MBK for the Mayor's Office as well.
Perfect. So you are the person we get to bug when we have some which we do. We have like 4 pending applicants, I think,
Yes, ma'am.
for folks who've.
Working on that, I already just got one passed with legislation, I believe, a week or 2 ago. So working with Chief Sims and Mel to close a gap on some of the other ones. So soon we will hopefully have them finished by the end of the year.
Perfect. So we have at least one board member who will be joining us and hopefully being sworn in sooner than later. Very nice to meet you, Mr. Sewell. Thank you for coming to the meeting in person, especially today when we know lots of folks have a lot happening. So appreciate seeing you.
Thank you.
All right, I believe next up, I do believe that we do have or will have a motion to go into executive session. So I'll turn it over to Dr. Ford.
Hi, thank you, Chair Burns. I would like to make a motion that we move into executive session to discuss neglect of duty of a board member.
Okay, do I have a second? Second. Okay, Mr. Tobias, are you moving your mic towards you? Were you going to say something?
I'm preparing.
Okay, perfect. All in favor of moving into executive session, please raise your hands. All right,
The main concern was if we're still streaming or if that's going to get cut.
I believe we are moving to a separate room.
Separate room, okay.
Yep.
Very good.
All right, we will reconvene at the conclusion of executive session. Thank you. have a second, please? Second. All in favor, please raise your hands. All right, motion carries. We are back on the record. If you please take note of our November case assignments, they are listed below. We did initially have prepared for this meeting, but we've decided to kick it to our next meeting, is just a review of some of the recommendations that Chief Bryant shared with us that had been done. We know that a couple of our board members who weren't able to be here today really did want to talk about those on the record, both in a positive way, but also to help inform the community of things that had been updated or policies that were being looked at and renewed because of the board's work. So we hope to do that in our December meeting, which will be Tuesday, December 3rd. Unless anyone has any other questions, anything you'd like to share for open topic, unless those exist, I would entertain a motion to adjourn.
So moved.
May I have a second? All in favor of adjourning, please raise your hands. All right, motion adjourned. Thank you all.